Hello, I am attorney Carol Avard, and I am going to give you some information that I hope will help you prepare for your hearing for service-connected disability compensation before the Board of Veterans' Appeals, also known as the BVA. At the end of this audio, I will show you a mock hearing on a case dealing with PTSD, depression, tinnitus, hearing loss, and a back injury. Service-connected disability is defined as the decreased ability to earn a living. The Veterans Administration assigns percentage amounts from rating schedules that represent the decreased ability to earn a living that each vet has. Service-connected rates go from 0% to 100%. The amount of compensation benefit goes from the lowest of $140, or 10%, to over $3,000 a month for 100% with no dependents. A 100% rating is obtained when an impairment is sufficient to render it impossible for the average person to follow a substantially gainful occupation. Even if a veteran is working, the vet can still obtain a 100% evaluation if the average person would be unable to work due to those symptoms. Total disability can also be given when the service-connected disabilities are less than 100%, known as total disability rating based on individual unemployability. This happens when one disability is rated at 60% or more, and if there are two or more disabilities, one disability is rated at 40% or more, and additional disabilities bring the combined rating to 70% or more. When the balance of evidence can go either way, the benefit of the doubt goes to the veteran. To establish service connection, the evidence can include service records, medical records, and lay testaments, and affidavits. Rates are generally not determined by adding them together. Severity counts first. The VA starts with the highest evaluation. For example, a vet rated 30% for one condition and 20% for another does not equal 50%, but rather 40%. The exception is when the disability is completely distinct, for example, cosmetic damage, pain, and limitation of function. Another exception is the bilateral factor, where they add 10% if both arms or legs are involved. For example, a veteran has a left elbow rated at 30% and a right wrist rated at 10%. The customary rating schedule rules apply, but since it involves both arms, a 10% increase is applied after they receive the combined rating. It is very important to include as evidence medical questionnaires completed by your physicians. Avard Law Offices has its own disability benefits questionnaires that should be completed by either the vet's treating physician or an independent medical examiner. Ask your attorney for the forms that apply to you. Your attorney and the VA also have telehealth examinations, including psychological evaluations, which we encourage the vets to utilize. Please remember that the cost of obtaining the questionnaires to be completed by the doctors has to be borne by the vet and not by the attorney. The BVA is an independent organization, part of the Veterans Benefit Administration, unlike the VA regional office. The BVA is required to follow its precedent opinions of the chief legal officers of the department, in addition to its regulations. It has its own rules of practice found in 38 CFR Part 20. Beginning February 19, 2019, a new way of deciding cases began with the Veterans Appeals Improvement and Modernization Act. I will refer to this as the AMA. Older claims are called legacy claims. The BVA mostly deals with service-connected disability compensation. The BVA chairman is appointed by the President and confirmed by the Senate. It is Cheryl Mason. The BVA has veterans law judges, or VLJs, and also called board members. They are all attorneys. There are 4 teams of judges. The judges assign cases to staff attorneys who are the first people to evaluate your case. The staff attorney will draft a tentative decision for review and signing by the judge. They decide 4 to 5 cases a week. The grant rate at the BVA is between 30 to 35% for either all or some of the benefits requested. And the remand rate is between 38 and 46%. The BVA can remand a case to obtain an advisory opinion from a medical expert who is not a VA employee. This is called an independent medical opinion. The BVA can also remand when the regional office, or the RO, made errors that need to be corrected, or the duty to assist at the RO level was not appropriately applied. If a case is remanded, the board must specify the questions that have to be presented to the examiner. At the BVA, prior favorable findings are binding on the board, and the duty to assist no longer applies at that level. However, the duty to assist does apply at the regional office level, so a case can be remanded by the BVA because the RO never applied the duty to assist rule. The BVA does a de novo review, that is, it independently reviews and decides what weight to give all the evidence, with giving credit to the weight assigned by the VA in the prior decision, with one major exception. The exception is that prior findings made by VA adjudicators, including higher-level reviewers, that are favorable to the claimant are binding unless rebutted by clear and unmistakable evidence. Prior BVA favorable findings are also binding on the BVA. A finding is a conclusion on a question of fact or on an application of law to the facts. In the new AMA system, the BVA can get either the regional office decision or higher level review decisions. In the AMA system, there are 3 levels of review. One is the direct review lane. Here, a decision is based only on a review of the regional office decision, that is, a review of the record before the regional office, and if the claimant sought higher level review, the higher level review decision. The BVA in Lane 1 cannot consider new evidence. The second option is the evidence submission lane. Here, the BVA reviews evidence that was before the regional office and new evidence sent in with a notice of disagreement, or sent in within 90 days after the board's receipt of the notice of disagreement. In the evidence submission lane, there is no opportunity for a board hearing. The third option is the hearing lane. In the hearing lane, the board considers the evidence of record before the regional office when the rating decision was made, and any additional evidence sent to the BVA or within 90 days after the scheduled hearing. Written arguments or briefs can be sent in regardless of the lane picked. Hearings and reviews before the BVA can be advanced if the veteran is 75 years old or above, or is under severe financial hardship or seriously ill. Hearings can be in Washington or by video conference. The board member sits in Washington during a video conference, and the claimant usually presents testimony at a VA facility. In Florida, it is in St. Petersburg. In the AMA system, there is no right to a travel board hearing, although in the legacy system there is such a right. In the AMA system, the board, rather than the claimant, initially selects the type of hearing the claimant will have. The board prefers video conference hearings. Due to the COVID-19 pandemic, the VA has been scheduling virtual hearings. They are done at the place of the veteran's choosing. Therefore, there is a temporary suspension of in-person hearings. We have requested the virtual hearing in your case. A Wi-Fi Connect allows a hearing to be held anywhere. The veteran can be in their home with their attorney or in a separate location, or they can be together. It is recommended that you use a personal computer or a laptop with a secure Wi-Fi or Ethernet connection in a private setting. Users may use an Android or Apple mobile device in a private setting. The preferred browser is Google Chrome or Internet Explorer if Chrome is not available. Apple devices require the VA Video Connect app. All devices must have a camera and a microphone for video audio capabilities. Android devices require no application, as the session will launch automatically in a web browser after the session link is selected from the email invitation. The virtual hearing room will have a chat box function for reporting connection issues or off-the-record requests. There will be a transcript available, which will need to be requested by the attorney, but there will not be a video recording. A large number of claims that come before the BVA include musculoskeletal disabilities, hearing loss, tinnitus, PTSD, depression, and related disorders. So we will look at how these are evaluated at the BVA hearings. The purpose of a hearing is to both present argument and testimony relevant to the issues on appeal. The judge will ask about service connection issues, the vet's symptoms, their frequency, severity, and how the medical or psychiatric impairments affect the vet's daily life. You should always try to describe each condition as numerically as possible. For example, if you have a back condition, what are your range of motion test results? For example, is your bending now limited to 50% more or less? If you have loss of hearing, how many feet away from you can you hear conversations? If you have pain, how do you rate it on a scale of 1 to 10, with 10 being the worst? If your pain or mental impairments affect concentration, how many pages in a book can you read? How long can you watch a TV program and remember what you watched? You need to know the legal requirements for determining your ratings. For example, if you have tinnitus, the highest rating you may obtain is 10%, regardless of whether it is in one ear or two ears. Your attorney will go over these numerical items with you during your appointment scheduled before your hearing. At your hearing, you will be asked about your symptoms. For example, if you have tinnitus, do you have ringing, buzzing, roaring, or clicking in the ears? Was the onset gradual or sudden? It can be triggered months and years after the underlying hearing loss occurred. The only requirement for 10% is that it be recurrent or happening time after time. Symptoms experienced 1 or 2 days a month or every 2 months should be entitled to a 10% rating. The rating also provides that a separate evaluation for tinnitus can be combined with another diagnosis, for example, Meniere's syndrome. Hearing loss is a separate disorder. It can be disabling when the auditory thresholds in frequencies of 500, 1,000, 2,000, 3,000, 4,000 hertz is 40 decibels or greater, or when the auditory thresholds for at least 3 of the frequencies are 26 decibels or greater, or when speech recognition scores using the Maryland CNC test are less than 94%. Compensation can be for both service-connected and non-service-connected, provided when service-connected hearing impairment in one ear is compensable to a degree of 10% or more, and non-service-connected hearing impairment in the other ear satisfies the VA's criteria for a hearing loss disability. Your attorney will recommend a state-licensed audiologist and speech discrimination test, as well as a pure tone audiometric test to establish your degree of impairment. If you have a musculoskeletal disorder, for example, a back impairment, or arthritis and scars, a musculoskeletal disorder also includes muscle damage, nerve damage, and limitation of motion of a joint. Scars can be assessed a 10% rating for disfigurement, a 10% rating for painful and tender scars, and a 10% rating for muscle injury. For arthritis, you can have a 10% rating if you have X-ray findings of arthritis and limitation of motion. Also, a 10% rating is appropriate for each major joint or group of minor joints. For example, the cervical vertebrae, the dorsal vertebrae, and the lumbar vertebrae. Painful motion of a major joint or groups caused by degenerative arthritis established by X-ray is deemed to be limited motion and entitled to a minimum 10% rating. Even if arthritis is not present, there can be a rating for a painful joint. To get more than the minimum rating for the joint, the pain should be productive of functional loss. For example, decreased exertion or moving back and forth, decreased strength, decreased speed, coordination, or endurance, and a medical exam report must address all of these elements. Pain also can be assessed with range of motion testing. Ask your attorney for the range of motion chart questionnaires. Separate ratings should be assessed for radiculopathy, which is radiating pain or complaints of nerve pain or numbness, bladder or bowel impairments, or erectile dysfunction. Similar problems occur when the VA rates knee conditions, which generally could be evaluated separately. Under the new AMA system, when the issue is an increase in disability rating, the BVA tries to only adjudicate what the disability rating should be for the period ending with the date of the regional office decision. Your attorney will also be arguing that the period following the regional office decision must additionally be decided. The AMA rules do not contain any such rule that limits a decision to a period up to the regional office decision, and therefore there is no reason to let this happen. The VA has only one single general rating formula for mental disorders. A rating of 100% requires total occupational and social impairment due to gross impairment in thought processes or communication, persistent delusions or hallucinations, inappropriate behavior, persistent danger of hurting yourself or others, intermittent inability to perform activities of daily living, including maintenance of minimal personal hygiene, disorientation to time or place, memory loss for names of close relatives, or your own name. A rating of 70% is made when there is occupational and social impairment with deficiencies in most areas such as work, school, family relations, judgment, thinking, or mood due to such symptoms as suicidal ideation, obsessional rituals which interfere with routine activities, speech intermittently illogical, obscure, irrelevant, near continuous panic or depression affecting the ability to function independently, appropriately, and effectively, impaired impulse control such as unprovoked irritability with period of violence, spatial disorientation, neglect of personal appearance and hygiene, difficulty in adapting to stressful circumstances, including work, or work-like settings, inability to establish and maintain effective relationships. A rating of 50% is provided where there is occupational and social impairment with reduced reliability and productivity due to such symptoms as flattened affect, circumstantial, circumlocatory, or stereotyped speech, panic attacks more than once a week, difficulty in understanding complex commands, impairment of short and long-term memory, for example, retention of only highly learned materials, forgetting to complete tasks, impaired abstract thinking, disturbances of motivation and mood, difficulty in establishing and maintaining effective work and social relationships. A 30% rating is provided where occupational and social impairment with occasional decrease in work efficiency and intermittent periods of inability to perform occupational tasks, although generally functioning satisfactorily with routine behavior, self-care, and conversation being normal due to such symptoms as depressed mood, anxiety, suspiciousness, panic attacks, weekly or less often, chronic sleep impairment, mild memory loss, such as forgetting names, directions, and recent events. A 10% rating occurs when occupational and social impairment due to mild or transient symptoms which decrease work efficiency and ability to perform occupational tasks only during periods of significant stress or symptoms controlled by continuous medication. A 0% rating occurs when there is a mental condition that has been formally diagnosed, but symptoms are not severe enough either to interfere with occupational and social functioning or to require continuous medication. Post-traumatic stress disorder requires exposure to one or more traumatic events. It is different for some vets. Some have fear-based symptoms, for example, re-experiencing the trauma and emotional and behavioral symptoms that predominate. Otherwise, they may have anhedonia, meaning a loss of interest in activities, or dysphoric mood, meaning dissatisfaction with life, and negative thoughts. Others have arousal and reaction externalizing symptoms, and others have dissociative symptoms. Finally, others may have combinations of these. Some veterans feel emotionally numb. For some veterans, it could last weeks, months, or years, or the vet may feel guilty about surviving when others did not, and they may have anxiety or nervousness, depression or deep sadness, nightmares or flashbacks, and re-experience the events with jumpiness, trouble getting close to people at work or in social or family situations, trouble sleeping, concentrating, avoidance of certain memories, or the need to calm down by using alcohol or drugs, which is called self-medication. A PTSD diagnosis should be made by a doctor. A medical diagnosis has to come from an expert competent to make that diagnosis. The VA adopted the DMS-5 criteria for PTSD in 2014. So now the vet no longer has to show involvement of intense fear, helplessness, or horror. The new criteria only requires being exposed to actual or threatened death, serious injury, or sexual violence in one or more of the following ways. For example, directly experiencing the traumatic event, witnessing in person the event as it occurred to others, learning that the traumatic event occurred to a close family member or friend, and the event must have been violent or accidental, experiencing repeated or extreme exposure to aversive details of the traumatic event. For example, first responders collecting human remains, police officers repeatedly exposed to details of child abuse. The stressor event can come from lay statements or buddy statements, but corroborating evidence is no longer required if there is an in-service diagnosis of PTSD. In addition, the VA now accepts the fact that just fear of hostile military or terrorist activity may be enough, even though the vet was not involved in any combat. Therefore, deployment to a war zone without participation in combat can satisfy the PTSD criteria, provided a psychiatrist associated with the VA confirms the stressor is adequate in the absence of clear and convincing evidence to the contrary. If the BVA denies the claim, there are two options. These include: 1, appealing to the U.S. Court of Appeals for Veterans Claims within 120 days of the decision, and 2, filing a supplemental claim with the VA for the same benefit with new and relevant evidence within 1 year of the notice of the BVA decision. And even if the Court of Veterans Appeals agrees with the BVA to deny the claim, the vet can still file a supplemental claim with the VA for the same benefit within a year of the board's denial. And if the regional office denies the supplemental claim, the vet can still pursue the claim by filing within a year of the regional office's decision a request for higher level review and another supplemental claim within 1 year of that court's decision. When a claimant has a hearing before the BVA, witnesses may attend and testify if needed. The claimant should attend if witnesses attend. However, the attorney can present arguments to the judge in the absence of the claimant if the ALJ decides that good cause has been shown. Claimants have the right to review the claim file before the hearing. This ensures that all the evidence was submitted is a part of the file. There is a limited amount of time to conduct this review. Usually 1 hour is set for a hearing. However, the attorney may request a pre-hearing conference for clarification of the issues or to stipulate to facts. The judge starts the hearing by presenting and clarifying the issues on appeal and discusses all of the documentary evidence. The judge should be referred to as Chairman or Madam Chair or Madam Chairperson or Mr. Chairman, although frequently representatives and attorneys simply refer to the person as the judge. The judge then swears in the claimant. A transcript is made of the hearing. Formal rules of evidence do not apply, so hearsay evidence can be used, and the attorney can lead the witness with questions requiring a yes or no response. The evidence should be reasonably relevant because the judge can exclude documentary evidence, testimony, and/or argument that is irrelevant or unduly repetitious. The attorney starts out by making an opening statement, briefly summarizing the issues pertinent to the facts and procedural history. The attorney announces who will be testifying, what the testimony will show, and the relevant legal arguments. Regulations require VA personnel to preside over the hearing to explain the issues and suggest to the claimant the type of overlooked evidence that would be advantageous to the case. The attorney should remind the judge of the duty under the Regulation 38 CFR 3.103D2 to inform the claimant if there is evidence that has not been submitted which would support the claim. The attorney may ask the judge to please tell us which elements of the claim are not satisfied based on the current evidence of record, and tell us if any evidence would be advantageous for the claimant to submit. The attorney will end the opening statement with a brief description of the relief sought and the reasons why the facts will show the relief should be granted. After opening statements, the attorney asks questions of the veteran and witnesses. The attorney may be making references to documents during questioning. After the attorney finishes the questions, the judge will elicit information rather than pressure the witness to admit something. The attorney may ask follow-up questions and may clarify the witness's answers to the judge's questions. Because the hearings are non-adversarial, That means that only the veteran presents evidence and arguments, and no one argues the opposing side. The judge is prohibited from cross-examining, that is, asking questions to discredit the prior testimony of the witnesses. Following the testimony, the attorney will give a closing statement and will ask for a copy of the transcript to be sent to both the attorney and the claimant. Note that the attorney or the claimant may also record the hearing with their own equipment or even videotape the hearing, provided it does not interfere with the conduct of the hearing. The BVA does not have to remand to cure a defect. The BVA does have authority to obtain additional evidence and cure procedural defects without remanding to the regional office. Sometimes a judge may refer to or rely on the manual 21-1 rules. However, the courts have found this manual is no longer binding. After the hearing, additional evidence may be provided, and subpoenas can be issued to compel attendance of witnesses or compel production of tangible evidence, including personnel records. Such requests are best if requested before the hearing. These procedures are addressed in 38 CFR 20.7090. It is further recommended that you watch the video on a mock hearing before the BVA, and after listening to the audio and mock hearing, you will sit down with your attorney to go over your future testimony and evidence in your file. Thank you for your attention and good luck with your hearing.